Hi, this is Mark Nejma from Newsweed.com. The Endo International stock fiasco seems to be coming to an end, at least within the next 6 months. It seems as if everyone got this letter that says you can opt out. And by the way, everybody is held harmless that's involved in any claim or preparing any claim or anything else. Or if you do opt out, uh, you have to take on the case yourself and prosecute it and spend money on attorneys and everything. I personally am not going to do that. I think the only hope I have is if the judge turns around and says, hey, you have a lot of capital, you have a lot of cash, you should really be paying your shareholders something. That's not what the plan says. The plan says that we're not going to get anything. And I guess by kind of accepting the plan, we're accepting the fact that we'll get nothing based on what I'm seeing. But again, I'm not an attorney. I'm just going based on what I've read. I'm just a guy who threw some money out, taking a long shot, a gamble, thinking that since the company was worth so much money, that by the time they divvy everything up, that the shares would be worth much more. But as it seems, um, we have these two options: either go with the plan or opt out. Opting out, there's a lot of things that I've read. For instance, investors evaluating whether to opt out should weigh both the pros and cons of doing so. There are many factors to consider. I'm reading this from Reuters. I'm not advising this. Uh, Practical, financial, and legal. There are many factors to consider. Practical, financial, and legal. Upon opting out, investors may forever forfeit their rights to participate in the settlement, class action, including the ability to share in any settlement or judgment. They also may be subject to the discovery obligations beyond those of an absent class member. Meanwhile, an opt-out plaintiff's lawsuit, that would be us if I did it, it's not timely filed or correctly prosecuted, may result in no recovery at all. I mean, to pay an attorney to look into when you bought the stock, how you bought the stock, um, what's been happening in the whole case. By the time I paid an attorney to do that, I'd be triple the amount of money that I spent on the stock. So for me, again, I'm not telling you what to do, but for me, I'm not doing that. I'm going to be a big boy and just accept that I made a stupid decision if I end up getting nothing. But do I have one little glimmer of hope? Meaning that I think the company is trying to get all these opioids settled, and by the time they do that, they may modify the plan to include the shareholders getting something. That's where I'm going to go. That's what I'm going to hope for. Um, anyway, let me read this a little more from you. Again, this is from Reuters. Reuters /legal industry /important considerations deciding whether opt out securities class actions 2021 623. So you can do your own search on the internet and find what I'm reading here. Determining whether investors' opt-out claims would be timely requires a thorough analysis of trades in the subject securities, the timing of the alleged misstatements and disclosures. Did they misstate? No, they didn't. They said to us that the shares would likely be worth nothing or little, and the applicable law. The consequences of any error may be significant. Over the years, district courts have dismissed as untimely number of cases filed by opt-out plaintiffs, finding that these investors filed their actions too late. Unless successful on appeal, these investors are likely to recover nothing through their opt-out actions, and it may be too late for them to participate in any class action settlement. Accordingly, it is critical that investors consult with experienced opt-out counsel, that means money, early, and if they decide to opt out, promptly secure a tolling agreement with defendants, intervene in an ongoing class case, or file their opt-out action. I guess the tolling means that if the company loses, the company pays the legal fees. Before opting out, investors must carefully assess whether it makes economic sense to do so. To that end, investors should calculate the amount of both their maximum and likely recoverable damages through an opt-out action. This is not always a simple exercise. The investor should ensure that its counsel, money, and brains, do you get a good counsel or not, retains an expert qualified to analyze its trading records and assess its potential damages under the relevant securities laws. For many claims, a damages expert will need to conduct an event study to determine whether the stock price declines at issue were both statistically significant and attributable to disclosures relating to the alleged fraud, as opposed to unrelated news or market forces. Did they tell us that the stock was likely to be worthless? They did. The damages expert will also need to analyze the investor's damages using both the last in, first out, and first in, first out matching methodologies, which may produce markedly different damage calculations. Careful consideration should also be given to impact on the Securities Litigation Reforms Act, bounce back provision, which may limit recoverable damages under the Exchange Act if the company's stock price rebounded within 90 days of the corrective disclosure. Way too complicated for me. Okay? I took a risk, and this is what happens. So, I can only hope that the judge turns around and says there should be some money for the shareholders. That's all I have to say. This is Mark from newsweed.com. I personally don't think I have a leg to stand on with this stock. Thanks, and have a nice night.